Okay, good afternoon, everyone. Welcome to the UNU Generative AI series. My name is Jingbo Huang. I'm the director of United Nations University Research Institute in Macau. As you can see behind my background, this is our beautiful building in Macau, a cultural heritage building. So UNU Macau leads this project initiative. We invite distinguished researchers, government officials, experts, and industry practitioners to discuss the generative AI's impact on our collective future, especially on health, education, environment, climate, peacekeeping, humanitarian work, etc. So we have already had a series of webinars since summer this year, and we'll continue to have more webinars. Today's webinar is focusing on generative AI and the role of law. As you can see from our speakers' backgrounds, they are either lawyers or regulators. So for those who are lawyers or having interest in law, this will be a feast, I hope, and an interesting event for all of you. I'm just curious for among the participants, who are lawyers? If you are, please type 1 on the chat. I continue to introduce the webinar. Please just type 1 in the chat. We will see how many lawyers are there. I will also like to introduce the panel members, and we're very grateful and honored to have a great panel consisting of several panel members. I'll introduce them according to the alphabetical order of their last name. So the first speaker in the panel is Mr. Damien Arthur. Damien is thank you for waving, is the Director of Legal and Compliance at Saki Partners. He's a seasoned legal recruiter with 2 decades of experience, specialized in sourcing legal and compliance talents for firms in Tokyo. And he's a lawyer by training. The second guest on the panel is Mr. Francesco Foghetti, and he is the Senior Legal Officer of the United Nations University. Francesco provides advice to the UNU system on a range of legal issues relating to the university's internal legislation, the resolution of legal disputes, and legal matters arising in connection with institutional development, partnerships, and funding agreements. Welcome. The third speaker is Professor Celia Matias, and she is an assistant professor, program coordinator of Master of Law in Portuguese language from the University of Macau. And her areas of research interest include law and technology, privacy and data protection law, intellectual property law, legal theory, law, and society. And we also have Professor Sarah Migliorini. Sorry, I butchered your name. Sarah is an assistant professor of law at University of Macau, and her research interests include artificial intelligence and big data, international litigation, and arbitration. So now that we have this wonderful panel related to the topic of the role of law, and we would like to discuss specifically on the generative AI's impact on law. And is a regulation necessary? Is it going to stymie innovation? Or we should let technology run free of regulation? And today's panel will be moderated by Sarah. And now I will give the floor to Sarah. Over to Sarah.
Thank you, Jimbo. This was a great introduction for me and for all the panel. Thank you so much for this invitation. I think you invite us to a feast, because for us, at least for the people in this panel, probably it is always a pleasure to share ideas and discuss the matters related to law and generative AI, at least since a year ago, we were put in the presence of this machine called ChatGPT that probably told us that generative AI was something to pay attention to. So thank you so much for this invitation. So we have been exchanging with the panel members about exactly what we wanted to talk about. And there's probably too much to say to concentrate on a webinar. So we're going to explore some issues that we think are important and on which we have experience or we have studied. We studied them. Just before I start moving the conversation around this virtual room, I would just like to share a little bit an introduction of this panel. So the title that we chose was Generative AI and the Role of Law, because exactly as you mentioned, Jimbo, regulators around the world right now are debating and trying to understand what is the best way forward to steer this technology towards the common good. There are many options for regulations. It could be plain laws, it could be soft law, it could be at the regional level, at the state level, at the international level, maybe. And so all these issues are on the table. My idea of this, and which I try to share with the panel members, and so then we can debate it, is that these are very important questions that we should totally address. But there is also another question of what of the laws that are already existing and that may be applicable to generative AI. There has been some, from certain areas of the business world related to generative AI, there is this idea that since this technology, it is so disruptive and so new as opposed to what we are used to use, for example, Zoom rooms, because generative AI is a whole other level. It probably doesn't really fit in any of the existing laws, and we should just start afresh and anew on regulating it. And I don't think that's true, that we have many existing laws that should be applicable to generative AI. And in other matters, for example, in IP, of which, for example, Celia will talk about later, there are new questions that really the law as it is cannot address. So I hope that with our conversation, we can shed a little bit of light on these issues as well, which is how I approach the role of law in the field of generative AI. Having abused my role as moderator way too much, I will start doing my job. And maybe I will bring in Francesco if he wants to share with us some of his experience with this disruptive technology and how it has affected your work and your role at UNU.
Thank you, Sarah. Yes, it was disrupting because perhaps everybody, ChatGPT came out quite quickly. And every day it was a new thing to know, to learn, to change, basically. And when we understood that some of us within our organization was starting using it and reading also a lot of articles regarding the way it worked and the potential risks, we start thinking about regulating the use of generative AI applications within our organizations. And so here I would like just to share the experience that we had within UNU regarding the development of our policy. It was issued last summer after 1 or 2 months of study, so basically quite quickly. You will remember that ChatGPT came out in November last year, and then we start, hearing news about that between January, February, or March. So we wanted to issue quickly our policy because we thought that it was important to at least write down a few red lines, basically something that should have been done or should have been avoided. being aware that the policy would have been subject to changes because the entire AI business is subject to daily changes. So it was overall a very interesting exercise because, yeah, there was great uncertainty. Everything was moving so fast. And so for this reason, we adopted a very conservative approach. Because, you know, the full implication of GAI applications to the work of UNU for now are very unclear. And so countries, or perhaps I recently read about one or two, have not yet released any regulation on GAI. The drafting of legislation on the creation and use of all artificial intelligence, including GAI, is behind, you know, the rapid pace and of development, the growth of GAI. So first of all, the first issue that we had to consider was the fact that we are a UN entity. So we are subject to special rules. The UN is subject to international law, to a certain convention regarding immunities, which means that we cannot accept the legal terms of GAI providers without negotiating those terms to make sure that they comply with the UN legal practice. So our first advice to our colleagues was, in the policy, was you don't have to use your UNU account to subscribe to ChatGPT, basically. You have to use your own personal account. Although we wanted to encourage the use of ChatGPT, but this was a sort of a contradiction, obviously. But then this changed because of Microsoft being enterprise. This changed because of Microsoft being enterprise. So the UN system, many of the UN entities use Microsoft Office 365. And when we understood that being enterprise, which is basically the ChatGPT of Microsoft, was integrated in the subscription to O365, we understood that we could actually use Bing Enterprise without any issue regarding the compliance of the legal terms to the UN legal practice, because we already accepted the terms of use of O365, and on that occasion we were able to negotiate certain contractual conditions, and therefore the use of Bing Enterprise was included in the entire package of O365. So that was a great achievement for us, because from that moment we could institutionalize the use of Bing Enterprise within UNU, because we could use the actual UNU email account for using the Bing Enterprise. But the caveat that I mentioned before applies to the other GAI applications. So the main issues, I think they are the usual suspect. The disclosure of confidential information, data, including personal data, and privacy. But again, this was somehow solved by Bing Enterprise because let's say, corporate subscription of Bing Enterprise does not disseminate the prompt, the instruction that you write in the chat. Although it provides you with all information that are available in the internet, nevertheless, the question that you ask to the chat are not disseminated in the internet. So that was a major achievement for us, because obviously we had to consider the information that we would like to use when using GAI. We shouldn't disclose confidential information, sensitive data, personal data, and so on. So that is a major achievement. And indeed, after the institutional use of big enterprise, we revised our policy to inform our colleagues of these new requirements. And that happened basically 1 month after the issuance of the first version. And I suspect that there will be other version. Actually, we are already thinking of a third version following the issuance of some guidance that was developed by UNESCO regarding the use of GAI, generative AI, in education and research. So we are still studying that document. Then copyright. You know, the emerging regulatory frameworks wants to require GAI providers to recognize and protect the intellectual property of the owners of the content used by the model. And this is becoming challenging to determine the ownership and originality of the generated works. So are text generating by GAI application original or not? So if the generated text is an original work, the author is the human who trained the model or the GAI system itself. So there are no uncontested answers to these questions so far. So how did we go about that? So we advised our colleagues to, actually our researcher colleagues who wants to use GAI for research and therefore for publishing their research, to run softwares that detect plagiarism. In that way, we would be able to attribute the source and to respect authorship and ownership of copyrights. Then accuracy of results and human-centered approach. We must not trust the output of GAI models, and we must not use GAI applications to infer conclusions, make decisions that could have legal, ethical, financial, data security, privacy, everything, implication. So GAI applications must only be used as an auxiliary tools, basically. It must not be a complete replacement for human work. That's basically my approach. The approach that I always had before even developing this policy, because it was obvious that it cannot be totally reliable. And it was like when we start using Wikipedia. You will remember that there were a lot of fake information within Wikipedia, but then they start adding links, footnotes, bibliography. And so in that sense, everything was more, it was more easy to understand the source of the information that we were using. And basically, this is similar to what is happening to these applications. So it's up to us then to make sure that the information are re-elaborated by us, or at least are double-checked by us. So basically, our policy is a work in progress. We are reviewing, it's in our policy, the fact that the policy will be subject to a periodical review. And as I said before, we are studying some guidelines that UNESCO developed because they relate specifically to education and research, and being a university and a research center, this would be another major basis on which we will rebuild the policy on GAI applications. Sarah.
Thank you, Francesco. This is really a very structured approach to this. And I have to say that it is really refreshing to see that some of the solutions that we academics, that, you know, we just try to push for some solutions, have actually been implemented by someone. So sometimes we are actually more practical than than we think, especially, for example, when you were talking about disclosure. Everybody has been advising not to put those kind of information on generative AI, at least at the beginning. But I just would like to point at two concepts that you used at the beginning. One was the one of red lines. Because when we talk about rules, of course, we need to find the red lines. And it seems that because of what you mentioned, that regulators are still a little bit in the dark about how this technology works, and things that are new come up every day. We have a problem about red lines. And that's why, you know, with the UNU and others, international organizations, there's a lot of need to work on the ethics of these applications. And the other concept that you use is the idea of transitional measures. We cannot think now to give a definitive legal answer to many questions that are out there, because this is still evolving. And so we have to accept that whatever we do is good now, but it will probably need to be updated farther down the line. So yes, just wanted to point it out. Maybe we will bring you back in the conversation later. Maybe I can ask Damien to jump in at this point, if he's still there, because I can't see his video right now. But if Damien, yes.
Hello.
Hello, hi. Sorry, I couldn't see your video because we have quite a few participants right now. So I would like just to bring you in, and maybe you could give some comments about all of this. I know you've been interested in discrimination and employment aspects of all of this, but you know, anything that you would like to contribute at this point. Thank you.
Sure, yeah. I mean, would you like me to contribute on those topics of anti-discrimination and labor, or should I just comment on what Francesco said?
It would be awesome if you could do both, because that would enrich our conversation.
Sure, yeah. So thank you, Francesco. Yeah, I think one of the key things is that we're definitely seeing the regulatory environments and and I think different jurisdictions are getting involved and not waiting. Like we're not playing a wait and see game with the development of AI models. It's definitely, there's a lot of discussions like this at a government level and at intergovernment levels on how to tackle, or what are the potential risks of AI and generative AI to society, and also looking at the tools that AI provides for society as well. So definitely red lines are, or people are considering, you know, what lines need to be put in place. So looking at that from like anti-discrimination law and kind of the possibility of inequalities or unequal treatment of individuals, I think it's probably easier for me to start in the global north and look at like Europe, because Europe seems to be very active in getting kind of like on top of that. And so we have an AI Act, which is the first EU regulatory framework for artificial intelligence that came out, I think, in June of 2023, so this year. So like not, that's like less than 6 months old. And the European Parliament have adopted this this AI Act, which is basically, it's them making a mark and making kind of clear to the public and to all members of society that the AI systems used in the EU, they want them to be safe, transparent, traceable, non-discriminatory, and environmentally friendly. Now, whether they achieve all of those aims is yet to be seen, but they want to establish also a technology neutral, uniform definition of AI that can be applied to future AI systems. And so the AI Act kind of sets out different rules for different AI levels of risk. And so it kind of makes distinctions on how AI is used. And it notes that that discrimination does exist. So the MEPs in Europe are kind of, they voted this AI Act in, and a resolution to kind of basically address discrimination and to ensure the right of privacy, and demands safeguards when artificial tools are used, especially in law enforcement, because AI applications are used in border control, and they are also used to identify sort of people in very kind of like in crowds, with using a lot of like face recognition software, and different APIs like that. So so they recognize that they did address concerns about technology discriminating, and they've already identified that AI-based identification systems usually misidentify minority ethnic groups, LGBTI people, seniors, and women at higher rates, particularly in the context of law enforcement and the judiciary. And so they want to recognize that fundamental rights should be upheld when these technologies are being used, and algorithms should be transparent, traceable, sufficiently documented, and when possible, to use open source software in the development of those AI tools, so that it's easier to investigate kind of the algorithms and what the algorithms are based upon. They also recognize an important point in respect of human beings' kind of dignity and privacy, and so MEPs are calling for a ban on automated recognition of individuals in public spaces, and noticing that citizens shouldn't be monitored, or should only be monitored when suspected of a crime rather than constantly monitored. And they also call for private facial recognition databases, like there's a Clearview system, a Clearview AI system, which is already in use by police forces for predictive policing and on behavioral data, to be kind of forbidden. So what that does is, I think it kind of links to in a database that already exists on potential criminals. And so there's this kind of assumption being made in linking to those databases that somebody who's committed a crime before is more likely to then commit a crime again. And so if that's fed into the algorithm, then it's going to start looking for people with an existing criminal record, which is definitely, a bias that is not fair, and definitely, and it kind of like it's prejudging sort of the environment. So that's an issue. So any MEPs kind of have put that forward, and they're very kind of like, adamant that kind of they're concerned that biometric data as well is being used to remotely identify people. And so border control gates that use automated recognition, smart lie detection systems for travelers in the EU should be discontinued, say the MEPs, and they're urging the Commission to open infringement procedures against member states who maybe pay lip service to this, but don't actually, are still using these kind of like border controls to monitor people. But I think that's interesting that they bring that up, because there is like a migration kind of, there's a lot of migration, there's a lot of illegal migration taking place in the EU. So they're definitely so AI has come in as a tool to kind of address that. And then they're saying, wait a minute, that's kind of an infringement on people's fundamental rights. But on the other side of that, like AI is also being utilized to create digital identities and digital passports for people who are misplaced. And so there are like NPOs and NGOs in certain states and are working with people who are misplaced and who've had to leave things behind, like their whole life behind and all of their documentation. And so they don't have all of the documentation, such as birth certificates, passports, sort of any documents that identify them. And so people are like, and some NPOs are building a digital footprint on creating kind of a digital identity, so that those people, if they do migrate, can actually be traced and there's like a digital record of their existence, which I think is definitely valid, kind of a good use of AI and digitalization, because it avoids people getting kind of adopted into sort of a slavery or modern day slavery situations. And so that's where, these tools can also be of great use to people who are in minorities. So the fundamental rights, finally, like just one of the MEPs kind of commented in the passing of the AI Act that the fundamental rights are unconditional, and that they're calling on a moratorium for the deployment of facial recognition systems for law enforcement. And they believe that the technology is ineffective and often leads to discriminatory results. So they're opposed to predictive policing based on the use of AI, as well as processing biometric data that leads to mass surveillance. So they believe that that's a big win for European citizens. Kind of at the same time as that, so we've got the UK, and the UK policing system actually uses and does use biometric data and does use facial recognition in crowds, but they have an obligation to the public to let them know that that's in use. So for example, if there's a big demonstration across a city, like a march for some political campaign, if there's sort of an organized protest, like a strike, or even it could be like the gathering of like a very, very significant football game where they anticipate that there could be some violence, or so there could be some situations that are disruptive to people's safety and to the public safety as well. They might employ sort of facial recognition, AI kind of camera-based tools and profiling, but they have to inform the public that they are doing that. So that's the kind of the police's, that's the UK police force's policy on that. So, and then they found that the police actually in the UK have actually they're transparent in their use of AI, and they tend to be quite kind of forthcoming on how it's used to kind of deter criminals, or to at least speed up the identification of potential criminals using facial recognition like software and a lot of CCTV. So so that maybe kind of goes against the kind of the ethos of the European laws, kind of like fundamental rights, possibly. But I think the distinction being made there is that this is the policing of one state and not border control. It's not really concerning border control and sort of migration of citizens, because when people are migrating, obviously they're an unknown entity as they're entering another kind of jurisdiction. So they don't want them to enter with an assumed identity or discriminatory identity. So that's one of the points. So that's kind of where a red line kind of, I guess, is being imposed to some extent by the European Union. And I think that's kind of my comments maybe for now on anti-discrimination. It's really kind of in the public sector. But I think what's also interested is that in the EU taking a leading role in promoting that, kind of promoting a framework of how AI is used, and also how AI is used in healthcare, how AI is used in the military, and also alongside the UN and international community. That sets a precedent, at least, of frameworks of kind of ethics and frameworks of use that kind of leads to businesses that operate in the European Union, or registered in the European Union, or in other jurisdictions, but who are making their services available to members of Europe. They have to observe those laws as well. So even if it maybe doesn't have, sometimes like a EU directive will have direct effect and have to be implemented by the countries inside the European Union, but then it has a secondary knock-on effect for businesses that are developing code and actually programming the AI algorithms and also the AI software that is often being sold to the governments, because it's very rare for a government to design their own proprietary sort of AI tools. So we're seeing that they're setting a benchmark, which is quite, I think, important, and it's a benchmark that puts human beings fundamentally at the center and ensures that like an AI does not trump the autonomy and the will of the people and the rights and the freedoms that have been instituted by a democratic society. And so I think that's kind of paramount importance to them. And so that does affect the public services, healthcare, justice. They ensure that that the AI should not replace human contact or lead to discrimination. So people should always be informed if they are subject to a decision based on AI, and be given the option to appeal against it as well. And when AI is used in matters of public health, so if it's robot-assisted surgery or predictive medicine, then the personal data of the patients must be protected, and the principle of equal treatment must be upheld as well. Because again, that's another issue, because statistically, if you run an algorithm through a computer, it could say that people of a certain ethnic group or a certain age maybe should be denied healthcare because statistically their chances of living for a certain period of time might be lower than somebody who's younger, or somebody of this maybe of this gender or of this ethnic background. And so they need to make sure and ensure that everybody is entitled to the principle of equal treatment. And AI technology in the justice sector as well, while it can also speed up the proceedings and take more rational decisions, the final court decisions must be taken by human beings, by judges, by qualified members of society, and be strictly verified by by people and subject to due process. So you can't have automated judgment or automated procedures, although we are seeing in some jurisdictions, you are seeing that some fines, especially for minor offences like driving offences, which have a statutory kind of obligation, and they're non-debatable, that it's almost an automated process, and some governments outsource that, and it's very much determined by camera technology on the actual number plate of people's vehicles. And so people are being auto-fined, but you can obviously appeal against that as well. So that's the point, I think, is that the AI will never replace human judgment, especially in terms of law, and in terms of healthcare, and in terms of border control, immigration, and justice. So I think I'll stop there. Thank you.
Thank you, Damien. This was, well, for me, extremely fascinating, because I've been working a lot on biometrics lately. And I'm very happy that we agree on many points. I think most of the things that you said actually can be related to one another, because on the one hand, you have the governments and law enforcement services across the globe have been hungry for facial recognition technology, emotion recognition, all these kind of systems that seem to, that do make it easier to identify people and even misidentify them and take decisions wrongly, as you very well explained. And so private companies have been incentivized to invest in this kind of technology, and upstream universities, even public funded university, have been also incentivized into this kind of research. So I'm a lawyer, but I try to understand how this technology works. And if you go back to the papers of 5 or 6 years ago in computer science about biometric in particular, there's a lot of research on how to identify people from a distance without them knowing, even if they're wearing a face mask and so on. So there is the incentives, to me, are all wrong. But they all start with how law enforcement services are hungry for this technology. And so I think that what the European MEPs are trying to do with their amendments to the AI Act is really laudable. On the other hand, what I'm seeing, I mean, the latest news is that some member states, including mine, are trying to depart from all this, this idea of fundamental rights, and are trying to push actually a much more favorable framework, at least for law enforcement. I don't know. I mean, it's still in the legislative process, it's still in negotiation, but we'll see how it goes. But yeah, thank you for bringing all this information to our attention. I think maybe, Francesco, you could, if you have anything to contribute about discrimination and all these issues, the floor is yours.
Yes, Sarah, thanks. This is indeed a very important topic. Damien, thank you. I just wanted to point out the fact that we also have a section on non-discrimination in our policy. And it's based on the recommendation that UNESCO issued to member states regarding the use of artificial intelligence in general. And obviously, as far as we are concerned, we adopt those principles relating to our policy on GAI, generative AI. So, and basically, it relates very, very closely to what you said, Damian. For instance, here under the UNESCO recommendation, we have two different topics for non-discrimination. The first one is about the non-discrimination regarding the access to AI technology. So member states should ensure an inclusive approach to ensuring that the benefit of AI technologies are available and accessible to all, taking into consideration specific needs, different age groups, cultural system, etc., etc. So member states should work to tackle digital divides and ensure inclusive access to and participation in development of AI. So a non-discrimination broadly considered. And then we have a different kind of non-discrimination concept that you also, Damien, mentioned, is about the minimization of bias, for instance, and discrimination in the use of AI applications. So this is an important subject, but obviously it's a principle based, and we haven't yet seen member states actually making this principle concrete in their legislation, in their regulation. For as far as we are concerned, our short section on non-discrimination replicates this kind of principles, and obviously we can monitor how we use AI and generative AI in particular, and this is up to us to understand how we use those applications in compliance with this principle. So for now, it's basically based on an oversight exercise.
Indeed, indeed. Transitional measures, transitional time that we are living for the moment. Okay, thank you. This was fascinating, and I would like now maybe to get a little bit more legal. I know there are many lawyers in the audience, and I would like to bring in Celia, our other speaker, Professor Celia Matias, because she's an IP law expert. And so we have briefly mentioned, and Francesco mentioned at the beginning, one of the most fascinating issues about generative AI, which is copyright, authorship, and then the issues of plagiarism, things that we have been confronted with when the internet became so widespread, the use of the internet became so widespread. But we are now in a brave new world where probably whatever rule we have is not so relevant or capable of addressing the problems anymore. So Celia is there. Yeah, I see her. So can you please take us a little bit through your research about these issues?
Thank you, Sarah. And good afternoon, everyone, or good morning or good evening, depending on where you join us. It is true. It was also very interesting for me to see the remarks that Francesco made in the beginning about the policies that that the UNU is developing in order to deal with all these issues in a moment where there's still a great deal of uncertainty as to how these issues are going to be to work out in real legal cases. I think there are two major issues when we talk about copyright and AI. One is about what do we do with the output of AI in terms of protection of that output. I am indeed working about that, but I have focused more on another aspect, and that's what I would like to talk about for a bit now, which is about infringement of copyright by the AI system. So both in terms of the training of AI and in terms of the output of AI. And this goes into also, I think, the one of the key ideas of this workshop, which is the tension between rights and innovation, between regulation and innovation again. So what we might decide to do in regulatory terms will certainly have an impact on innovation, and I think we need to reflect on the consequences of that as well. So how do we frame this issue of a copyright infringement and AI? Well, it's not a news that generative AI depends on data to exist, and lots of it. And I think it's understood that the more data, then the better, the more accurate it will be, or at least we hope that that is the case. So AI needs to tap into large quantities of data. And we have that data, let's say, in the wild, due to the fact that for now, several decades, we have been using the internet. And because of the architecture of the internet, how it works, how we have approached it as well as a public, there's a lot of data available openly on the internet. And the question, the major question in this point here is this data in the wild really free to take? And when we use expressions like data mining or like AI training, it seems that we are machine learning. It seems that we are indeed seeing this data as a free resource, like digging into the ground and finding some minerals, some diamonds or something like that. We also mine this huge amounts of data in order to extract something of value, like whatever output we might be talking about. Now, when we talk about using this comparison, when we talk about the soil, this is in general either owned by a private entity or owned by the state, as is, for example, the case here with most of the lands in Macau. So in order to mine diamonds out of the ground, you need to enter into a contract with someone who owns that ground. And in the case of data, each grain of sand might have a different owner. So we are here, I think, with a very complex question. Also compounded with the fact that data is intangible. So when we have intangible assets, we have to ask the question, can they be appropriated? When we talk about personal data, can personal data be appropriated? Is personal data the property of the data subject? I think that is in a whole different set of questions. Here in our case, we are talking about intangible assets that have been, due to options of the legislator over time, has been granted exclusive rights. And this is the product of intellectual labor, such as inventions and creations of other kinds. So, which is the case of copyright. So we're talking about artistic, literary creations, and so on. So do these intangible goods, can they be appropriated as part of these big data sets that need to be used in order to train artificial intelligence? There are, of course, orientations in the sense that these rights need to be protected. It cannot, AI cannot be trained to the detriment of these rights. But then we have further technicalities to deal with. One of them, and this has been referred to as the problem of input, is, as is understood, AI training has to involve, and those here who are more on the technical side, I think, would be, at least on my part, most welcome to comment on this. It has been understood that there is some copying of the data at some point during the process of training. And copying corresponds to the core exclusive right that is granted by copyright, which is reproduction. So traditionally, if someone writes a book, only that person or those who that person authorizes, in return for a remuneration or not, are allowed to copy the book. Now here, we already come, this is a question that now with AI, it doesn't appear in the void, because we already have the internet and other technologies that have raised comparable questions on whether all copying of a copyrighted piece of data is an infringement. And that's not the case. So there are cases where copying copyrighted work in and of itself, it's not an infringement. We are talking, for instance, of transitory, temporary copies that are part of a technological process. We have this in EU law, we have this in other laws around the world, and in case law as well. So now I think we are in the process of understanding whether these principles apply to AI training and in what way. So this would be the first layer of problems, to understand if whatever is happening technically in AI training is a reproduction for purposes of copyright, and if so, is it relevant in order to attract infringement? So this is the first problem on the side of input. Let's assume that we understand that this is the case, that the copying, the whatever storage or use of the data that is being done during the AI training is not under any of these exclusions. Then the second question is it an infringement considering other exceptions that exist in the legal system? And here, to those who are lawyers, this is all probably very basic, but let me introduce anyway the concept of fair use. This is a defense that exists in the United States and other jurisdictions. We have fair dealing, which is something similar but not exactly the same. in other common law jurisdictions. But it's the idea that certain uses of copyrighted works are not infringement, even though they could be. And in the US, at least this has to do with the application of 4 factors having to do with the type of use and type of works, whether the use is transformative, whether it affects the market for the original work, and so on. In other places, we don't have such an open exception, as such an open defense. We have lists of exceptions. And some of these already come from a previous phase in which we were dealing with search engines and things like that, where it was necessary to decide what to do with text and data mining. So this idea of finding something within text and data. And so several jurisdictions already have exceptions for text and data mining. And now it's a matter of deciding whether these apply to AI. It seems that at least there are some scholars that are in favor of this, that AI training is a type of text and data mining, and so these exceptions apply. I think that's the orientation in the EU. But let's wait also for the AI Act to see what contribution that will bring. And other countries such as Singapore have more recent legislation that clearly include at least some types of machine learning. So I think we see several jurisdictions including these exceptions to copyright infringement, tailored for these activities. Under certain circumstances, such as the data being accessed lawfully. So this is a principle I think that we can see in already in legislation like the Digital Millennium Copyright Act in the US, and also cybercrime legislation. So the idea that if you try to overcome some technological barriers in order to obtain the data, your access is unlawful, and therefore it cannot benefit from this kind of exception. And this has, it's at least in the EU, there's a more favorable framework for text and data mining for research purposes, for non-commercial purposes, but it does exist as well for commercial text and data mining, and as well as Singapore and Japan, which were the 2 other jurisdictions that I looked at. And that also have this favorable framework. Another aspect is, and it follows from these exceptions, is that of an opt-in versus opt-out system. So what the EU did was the exception for scientific research is mandatory, but this exception for commercial text and data mining, which will arguably apply to these generative AI systems, is subject to an opt-out right on the side of the right holders. So I think this is already showing some perspective on how this problem might be addressed, but I will have more on that later if we have time to further discuss. Now, I would only like to make a note on the output, because at least from a theoretical perspective, this is a very interesting question. So once you have trained a system to generate either text or images or music or whatever it is, you have also the output to consider, whether whatever is coming out of these models, regardless of what we understand about the training process, whether this is an infringement. In some lawsuits in the United States, and there are at least two that I know about. One is about ChatGPT against OpenAI, and the other one is against some image generator systems like Stability AI and Midjourney. So what the plaintiffs have argued is that because the system collects all this data and then does something in there that leads to the creation of this output, then because there is the DNA of these works in the output, all and any output of a generative AI system is a derivative work. And courts, I think, have pushed back somewhat on this claim, but it's still very interesting. A derivative work is a work based on another work, and this has been discussed in the courts in cases like remixes of existing songs, in the cases of collages done by artists, of fan-written spin-offs of known stories, and so on. So usually this involves an analysis of both works, whether elements have been used in the derivative work that belong to the original work, whether this part that has been used is substantial or not, and a number of other considerations. So if we accept this argument that by the circumstance that in some way a work that was included in the data set for training an AI system was the origin of the output, can we then say that all generative AI output is infringement of copyright? I think this, at least from a copyright perspective, it's not acceptable, but I will also refer this for further discussion if we have time for that. I just want to make a final note on opt-in and opt-out systems and the possible role of international organizations, which was the second topic that I had picked up from Sarah's very nice and comprehensive list of topics. So I think if we are headed to or at least a bifurcation of systems, one in which we allow copyright holders to opt out, or maybe a triple system, one that we don't allow them anything, one that we allow them to opt out, and one where we require their consent in order to include any copyrighted works in a data set, which will be the opt-in system. I think we need to ensure some legal certainty here and prevent abuses. Why I say this? Because it's not very difficult to produce a copyrighted work. Let's imagine I take out my phone, I take a picture of my window, and I say that this is a copyrighted work. And I put it on the internet and I forget about it. And now I have, say, in my Instagram, 100 pictures like this. And I know that this has been scraped for some AI training, and I claim to receive some compensation for this. This is a possible scenario. There's also a lot of orphaned works, works that belong to people who have deceased, and their relatives are not aware of these works or these social media accounts or blogs or whatever. We have basically a lot of digital clutter going around, as to which it would be very difficult to ascertain whether it's copyrightable, whether it belongs to the person who's claiming ownership over it or not. And we are at the risk of creating a chaos if we go into, especially an opt-in system in a scenario like this. So I think, and this is not a very developed idea yet, but I think we could consider some form of registration requirement in order to enjoy remuneration as part of any possible system in which we collect remuneration from AI companies, if this comes to be. And here, considering the cross-border nature of these things, it would have to be an international body that could administer this kind of system. We already know that WIPO administers registration systems for patents, for trademarks, for designs, for a number of IP rights. It has not been the case with copyrights for some reasons. But if we circumscribe the question to deciding whether this work can be copyrighted and registered in order to join any opt-in or opt-out systems, perhaps this could be useful in preventing this rather chaotic situation that I'm anticipating. But maybe this is not this concern will not come to be. I don't know. And the second role I think that we might see happening is also in dispute resolution. I just had a look and I checked on the WIPO dispute resolution system. So they have an arbitration and mediation center, and 24% of the cases decided are copyright disputes. So I think we might also see AI-related disputes being discussed there. But I will leave it at that, and I welcome further questions from you or from the other participants. Thank you.
Thank you, Celia. This is fascinating, and IP really raises a lot of interesting questions. I think maybe Francesco, you wanted to contribute on this, if I'm not wrong.
Yeah, perhaps just a question to Celia, and indeed this is a very interesting but very spiky topic, right? So still very uncertain territory. So and also I know that there are class actions and lawsuits in the US every day brought by owners of copyrighted work used to train GAI applications, right? So, and also I think that OpenAI and Microsoft also offer to take care of those lawsuits brought against their users. So they are even gambling on these things, and probably are very optimistic. I don't know. We will see the first decision. But anyway, Celia, I wanted to build upon this issue with a colleague of mine here at UNU. Actually, first of all, I think a confirmation from you, because we noticed that GAI applications do not copy and paste when they generate responses. They re-elaborate. That at least what we we even tried. We said, write a paper of 1 page based on this topic, and we asked it 2 or 3 times, and the response wasn't identical. It was different all 3 times. So they re-elaborate things, perhaps depending on the source available at that moment. But I'm not sure about that. So that's something I wanted to bring to all of you. But lawsuits brought by copyright owner of copyrighted work in case of a work used to train a GAI application. To us, it's like I read 3 books, I train my brain based on those 3 books, and I write a book myself. I don't copy and paste what is written in the 3 books, but obviously I'm influenced by those 3 books. And I elaborate. You also mentioned derivative work. But if it's an original work, it's not a derivative work. And then how do we go about that? I also mentioned this very topic when I spoke about our policy, and we said we don't want to have a decision, basically, and we just want to inform our people that need to be careful about that. So what do you think about what I just said? I mean, myself, a human being, reading 3 books and then writing a book which is not identical to any of those 3, but definitely I took something from those. So does a GAI application do the same according to you? Because we couldn't understand, we couldn't come up with an answer,
A controversial topic, right?
Yes. And we had some conversations about this as well a while ago. Yes, very good question. I agree with you. Yes. What a GAI systems do is not a copy paste. It's something else. I looked a bit into the case of diffusion, which is the technology that is used for image generation in all this Midjourney and similar systems. And even the way that it's explained, it's like turning images from the data set into noise, and then turning the noise into an image according to what the user prompts. So that's why I was saying earlier that I don't agree with the argument that has been used in these class actions that all GAI output is a derivative work. And as the courts have already stated in some cases, though not finally, just as in sort of interim decisions, we will still have to look at the comparison between the output and the works that have been claimed to be infringed. So is there a substantial similarity between them? Can we see clearly that that the image was copied? And that will depend on the prompt. It will depend on whether, especially in image generation, whether you ask, for example, make me a portrait of Harry Potter, I don't know, jumping rope. So if you really ask for this kind of work, then there are clear elements of another work in there. Now, a further question that I would ask is, there are elements that are identifiable, but then there are also elements that are not identifiable and were also used to create this work. So how does this work? Are we discriminating the non-famous artists that created, say, a foot that was used in this kind of output? I think these are still questions to address. Your other question was, how do we compare this with a situation in which a human learns from existing work and then creates something of their own that is based somehow on the memory in their brain of, say, a Picasso that they saw in the museum, or of hundreds of paintings that they saw throughout their life, as well as natural elements and whatever else we are exposed to in our everyday life. Is there a difference between this and the learning done by AI? And I think this is the core conceptual question that has to be answered, and it will have to be a combination of law and technology, because we need to better understand what is actually happening in these systems. I mentioned earlier the issue of the copies, of how are the copies being used? Are they being stored? For how long and in what way? So these are tech questions on the technical side, but also on this conceptual side. And there has already, an article has already been published that touches upon this. It's called "The Right to Fair Learning." It's by author called Lamley and another co-author that I don't recall, Casey, I think. And their argument is very similar to this. Machines should be allowed to learn within certain limits, as long as they are not created specifically to infringe copyrights. Then we should allow machines to learn, to absorb this data in order to generate new works. So just to conclude, I do think that this issue is very controversial. I tend to say that we should tread carefully in overprotecting copyright, considering that it's already very easy to obtain copyright, and that once you have it for your whole life, plus 70 years in some cases. And in order to not overly contract the public sphere, so what we are allowed to do with the knowledge that already exists in the world, I think we should not jump the gun, so to say, and consider that everything is infringement. From a policy standpoint, more than from a copyright standpoint, I think opt-out systems should be considered, because aside from a copyright issue, we have a social issue, which is the livelihood of people who are engaged in creation. And so from that perspective, I think we can consider some mechanisms, not because it is conceptually a copyright infringement, but because we need to do something about it.
Okay, thank you so much. I feel this conversation can go on, at least for me. It's totally fascinating, and it's really at the crossroads of law, technology, but also other disciplines. Like it's really about what qualifies as art and what's the function of art and copyrighted work within society. So this is all very interesting, but we move on a little bit with the program, and I've been informed that we have we're lucky enough to have a cyber security law expert, the Honorable Judge Lalta Ika from the High Court of Tanzania, that should be in the audience. And we would very much like to have some comments also on that aspect, on cybersecurity and law. Thank you very much.
Thank you very much, Sarah. Good morning, everyone, from Iringa, Tanzania, in the center of our country. It's a pleasure to participate. And I'm very glad and very excited. I've learned a lot. Thank you very much, Cecilia, for your presentation. It has widened my perspective. I participated in the WIPO Judicial Forum about a month ago. and judges from around the globe came together, some physically and some of us virtually, and we had very interesting conversations on generative AI and copyright AI. That discussion, from what they speak, we are not in a very smooth road. There's a lot to be done to kind of get the concepts clear. For some of us who have done intellectual property at graduate level, I did an LLM in intellectual property, and so giving reasoning on whether I can write an opinion as a judge that there are copyright issues involved in generative AI depends on a lot of things. For example, I would first ask myself whether this is copying of content or an idea. Francisco just gave an example of, putting a question and then you don't get identical answers. That means, from a copyright perspective, that is really an idea. For example, if I want somebody to write to tell me about Serengeti National Park, I asked that question in the morning. I ask again after an hour or two, I get different questions. Now there is this gentleman coming to court and say, okay, I wrote a guidebook about Tanzania. I have a chapter on Serengeti National Park, and therefore my book has been used to train AI, and therefore whatever output that comes out is based on my work. So I need to be compensated. Well, superficially you can agree, but it takes a lot of ideas coming together for you to get that output. That is the first level. And so we are waiting for the opinions that are pending from some US cases that are being class suits that have been taken. Secondly, another perspective, and I talk this more or less as a judge, not as a scholar or something, is a balancing act. We are always in a balancing exercise, balancing between the right of an individual and the right of the community to access to knowledge, to foster creativity, to encourage discussions and stuff like that. Now that brings the other question that Celia raised on whether only the big guys qualify for remuneration. What about the small guys who have also contributed? Earlier on, when I joined, I heard the speaker talking about the accuracy. Do we pay everyone, even those who have just put in the information, or we have some higher threshold for scholarly work, extremely creative? And that, again, is an aspect of copyright which has no discrimination. Whether you just put data without any creativity, or you just take a photo, like Celia said, you have copyright. And copyright is automatic. You don't have to register anywhere. So I want to thank you for these discussions, because they also give us some more platforms to learn. And if next time I am asked to contribute to the WIPO Judicial Forum, I think I'll borrow a lot from Celia and Francisco, and they see that, we don't lock up ourselves and say we know, like Celia has correctly said, it's an issue not only of law, but a lot of economics are involved, a lot of balancing exercises, a lot of science and technology that goes into producing a work that we think is copyrightable. Thank you, Sarah, for the opportunity.
Thank you for bringing this perspective to us. I do want to leave enough space for everybody. There's a discussion going on about what's creativity on the chat, which is really very interesting. I may just very briefly, if I don't surprise him, just ask Damien if he wants to comment on any of the issues that we just mentioned, and then we can open to the floor for Q&A. If Damien is there.
Yes, thank you, Sarah. Yeah, so thank you, Celia, and thank you, Elemeni from Tanzania. Very welcome. Very pleased to see you on here. So yeah, just a couple of comments really, and that was just that. So there's an AI ethics researcher and kind of climate protagonist called Sasha Lucini, and she looks at these kind of issues, and she says, can you legislate the training of AI models? You can't really do that, but what you can do is you can legislate the deployment of the AI models. So sometimes I think the legislation, the regulatories, they're looking at like, because the models will produce certain biases and they'll produce data sets, and sometimes they'll produce what's called hallucinations. And so sometimes the data is incorrect, and it has to be then like corrected, or the algorithms that they're being relied upon, and also the input is being given by the machine will have a certain bias to it, and so there is like some data that the AI can that the AI produces that you can't reduce, but that's where the AI, the models are actually in the process of training themselves. So you can't necessarily like legislate on that, but you can legislate on the deployment of the AI models. And she thinks that's where we should be kind of focused on. And she says, yeah, that the legislators should tackle what's happening here and now. And so she cites copyright infringement, biases in models that influence recruitment or can lead to wrongful arrest. And she says these things are not existential or hypothetical, they're present, and so we should be regulating for them. And that's kind of also she says that the business world can demand more transparency from the AI developers, because there are ways of restricting the models, but the gist is not to run headfirst into sticking generative AI into everything. But I think sometimes when this new model comes up, everyone wants to adopt it immediately, but then that's not necessarily good for business, because if you haven't got any constraints on the AI, you haven't got any constraints on the way it's going to be utilized in business. So so she's kind of aware of that. And then finally, I just wanted to say that, like from the South in the developing world, there's a woman called Emma Rutkamp-Bloom who has led a UNESCO kind of group that drafted the 2021 recommendation on ethics of AI. And so she sits in the UN's high-level advisory body on artificial intelligence, and is looking at how to leverage AI to accelerate delivery on sustainable development goals, to oversee the governance of AI, which I think is important, because then the focus then shifts to ensure fair access to and ownership of data, because that's an issue that's consistently raised from the African side, because it's an issue that's almost consistently ignored in global conversations, because the actual developers of AI tends to be from the global north and tends to be kind of a very English-based model, a very US-centric based model. And so the question there is like, what access do we have, even and fair access to these things? And for copyright infringement, who's protecting the copyright and the infringement of copyright? Is it just those that are wealthy, or is it like evenly distributed to all artists and to all users of AI? So they're looking at those sort of things. And then in the global South, I can continue just quickly, in China, they're kind of pushing for watermarking of AI. They're pushing for watermarking of AI generated output. And that's kind of to the point that I made above, is that the output of AI, it's like, who made this? Where does it come from? Who created this? And so it's like tracing the origins of content. because I think that's really, because if people are relying on the data, you want to know who created the data. And so so they're pushing for that. But that's so they've got this idea of watermarking, and the EU too is pressing for watermarking and content labeling as part of its proposed AI Act, which won't be enforceable until 2026. But it wants to classify the AI applications according to the risk, which I mentioned earlier. But like models which respond to generative AI like ChatGPT, that would place restrictions on them, which are called foundational models. But at the same time, in Germany and France and Italy, in early November this year, they began questioning these proposals and instead preferring kind of self-regulation through codes of conduct and sort of saying, we don't want to watermark or stamp or stifle the innovation because it could wreck any chance of tying up legislation before the EU's elections, and so they want to delay the implementation. So, but in the developing world, they do believe like that, this woman, Emma Rootcombe-Bloom, she does believe that the only sustainable AI is lawful AI, and it has to be trustworthy and it has to be responsible, and it cannot be responsible for itself. It's like human beings have to be accountable and responsible for the AI. And so in that watermarking process, somebody from, I think it's Facebook or Meta, they were actually calling for, well, they've got a system, I think, where it's called, what do they call it? It's like radiation watermarking, which to me is a little bit outside of my kind of expertise, but it's radioactive data for AI watermarking. So this is a technique where it's a concept that determines which data sets were used to train a model. So rather than the output and then stamped with a watermark, which is kind of like how we conceive watermarks traditionally to be, is you produce the output and then you stamp it. This actually has a radioactive tracing back to which data sets the model has been using. So you can see that the output of somebody has actually maybe relied upon a certain data set, algorithmic kind of model. So I don't know if that's useful. But anyway, I'll wrap it up. Thanks.
Thank you so much. That was really fascinating, and I hadn't heard of that technique. I think watermarking is a big topic also for legislators right now. Really, really interesting. In the interest of time, I really need to open the floor for questions from anyone from the audience. So yes, you're free to type them in the chat, or if you want to just speak, raise your hand with the Zoom function, and I guess we can give you the floor. Yes, Nazar Kirama, may I ask to unmute yourself and maybe also switch on the video if that's okay?
Hello, everyone. Can you hear me?
Yes.
Okay. Oh, thank you so much for everyone, for every presenter. I think it has been a learning curve on this, generative AI series. And today was my first time to participate, but I think I have gained a lot. My contribution really is on the policy side of the equation of these things on generative AI. And I would like to recommend, because some of us, do participate in different networks where either we are contributing to the, policy making for the emerging technologies like AI. And my recommendation has always been that we have to embrace smart regulation. I think regulation is very important, but it has got to be a smart approach in terms of how we regulate the new technologies such as AI and more so on the generative artificial intelligence, because it is extremely disruptive. And in many quarters, the reaction to this has been really a knee-jerk reaction, trying to actually go and quickly regulate these new technologies. I wanted to imagine in a situation where a person like Sam Altman, who started the Open AI movement, was in a situation where he couldn't probably do what he did, that he had to consult with the regulators first to do what he did. I think we wouldn't be in a position today, discussing the disruptive nature of the generative AI, which I think it is helping a lot in terms of creating solutions in things like food security, education, health, and so on and so forth. So my take today will be that let us embrace smart regulation, and let us advise, for those of us who are experts in this field, we should ensure we contribute in our networks for the policymakers to embrace smart regulation. Thank you so much.
Thank you, Nazar, for this also contribution. That is true. What would we be doing right now if Sam Altman couldn't launch ChatGPT 1 year ago? I don't know. I don't know if the lawyers would have been appraised of generative AI if we didn't have that. But is there any other question or comment from the audience or the panelists? I'm not sure. I don't see any raised hands. I maybe I'm looking if there was a discussion about creativity, right, on the chat, but I'm not sure if the people who were debating that still have questions or not. Well, if there are no more questions, I would just invite maybe the panelists for a 1-minute conclusion of this great roundtable before we wrap it up. Starting maybe with Francesco.
Yeah, just one comment following the last remarks of Mr. Karama. So on Altman, basically there is a say in the Silicon Valley, better to do and apologize than to ask permission. So that's exactly what people like Altman do. And you definitely have to go ahead and then think about regulations afterwards, although this can be disruptive and we can have another webinar about this concept. But my last remarks, again, regarding the approach that we adopted here at UNU, there are a lot of caveats, a lot of don't do that and consider everything on a case-by-case basis, but nevertheless, we are encouraging a lot our colleagues to use these systems. I am personally quite fascinated by their potentiality. I think it will help a lot our work, my work, the research of the university. And so a small example, our colleagues at the ICT office at UNU, they are working on a chatbot for internal use based on internal documents. This thing can answer queries about UNU rules, regulations, our database, explain, processes. This is more administrative oriented, but, it can help the work of everybody. And so I'm very curious about how these things will develop. And so, AI is not, or generative AI is definitely not a shortcut like somebody might think, but it's definitely an improvement of our work.
Definitely. We have colleagues developing the same for our courses, not at our universities, but in other universities. So imagine the students that could actually have real-time clarifications about the coursework when they review. It's the same thing. It's very useful, certainly. Maybe Celia, do you have any final remark?
Thank you. It was really great to have this discussion and to see that some of these issues really do resonate with the other participants. And I think there is a topic in particular that I would like to, in the future, follow up, which is the global North, global South issue. When we look at these discussions, particularly on copyright, I think we see a focus on traditional copyright on the global North, with on one side AI companies that have significant resources, and on the other side right holders that also have a lot of resources, and that they can afford to go fight each other in court. But when we talk about creators and entities with less resources, when we talk about traditional cultural expressions that are not so clearly protected by copyright, I think we should also debate what is the impact of AI on these realities and bring them into the conversation. So I think that is something that we should also proceed with. That's my final remark.
As interesting as your initial remarks, of course, and I've been on that. Can I ask Damien if he has any last minute comment or conclusion?
Oh, yeah, just finally, I just want to say that, like the UK government has kind of launched a kind of AI Safety Institute, which is going to be kind of like testing and sort of observing sort of the capabilities of AI, and seeing and like working in a collaboratively way with like a lot of AI nations. So they held a summit in November, and then I think the next summit's going to be held in the south of the world by South Korea, and then I think there's another summit scheduled for 2 years or maybe 2025 in France. So there does seem to be some global participation in sort of testing, and I think that's the kind of the safety testing of AI is kind of like a good step forward, because rather than jumping in too quickly and regulating and putting kind of lots of rails and restrictions on what the AI should be doing or could be doing, on at least from a business point of view, I think it's like testing and seeing the safety capabilities can also unleash the potential of AI to maximize and improve people's lives. And so I think that's the objective there, is that they don't want to restrict, like the actual technical breakthroughs of AI. They want to just make sure that it protects the fundamental human rights that are kind of advocated by EU, by the UK, and by like most nations in the world. So I think that's a good step forward, and it's a step forward that where China's involved, the US is involved, Europe's involved. So everybody's gathering around the same table instead of it being very kind of like cut and driven by like monetary, like those with the most power or the most influence from a monetary point of view. So I think that that's very encouraging.
Absolutely, absolutely. Keep watching this space, as they say, because it's all in evolution. I want to thank everybody, the speakers, Francesco Foghetti, Damian Arthur, and Celia Matthias. And I also thank Jimbo for the invitation to run this webinar. Maybe I give you back the floor for the final word.
Thank you very much, dear panel. I hope that I would like to invite all of you to give a virtual round of applause to the wonderful panel members and also the wonderful moderator. Thank you very much. And also like to send a special thank you to the Honorable Judge Laltaika from Tanzania. Please do keep in touch with us and please reach out. I'll type my email address in the chat, and you know it's serendipity, but it would be really wonderful to continue to work with you. Please do reach out to us. Dear colleagues and dear friends, thank you for being here, participating in the webinar. And as a heads up, and our next webinar will take place in January. It's going to be generative AI and education and research in collaboration with UNESCO. And most likely we'll have senior managers from both UNU and UNESCO. So feel free to pay attention to our website and join us 25th of January, 2024. Happy holidays, everyone, and see you next year.
Thank you. Bye-bye.
Thank you, Jimbo.